All right, thank you. Welcome, everybody. My name is Paul Burns. I'm a partner at the law firm of Procopio, Corey, Hargreaves, and Savage. I'm based in Los Angeles. I'm also an arbitrator and a mediator. And I teach at Pepperdine Law's Strauss Institute for Dispute Resolution. I teach arbitration and mediation there. I'm really honored to be here today to talk about the subject of fish out of water, how entertainment attorneys can win in arbitration, or from Dr. Strangelove, how I learned to stop worrying and love arbitration. And it's an honor to be here today with my co-panelist, Neville Johnson, the senior partner and co-founder of Johnson & Johnson LLP in Beverly Hills, and Aaron Galthelf, vice president of the commercial division of the Pacific region for the American Arbitration Association, and he's based in San Francisco, California. So today we're going to learn a little bit about arbitration and try to make everybody feel more comfortable with it. You're going to have an opportunity to submit questions, and we'll try to get to some of them during this session. But we have a lot of material to cover, and we have some pretty dense slides that you can take with you in lieu of a separate article. So you'll have this information to refer to in the future. So why don't we get started with our first slide? So there's two people in history I just wanted to mention going back to the 18th century. The philosopher Voltaire once said, "I was never ruined but twice, once when I lost a lawsuit and once when I won one." And former Chief Justice Warren E. Burger said to the American Bar Association, I think that was back in the 60s, "Our litigation system is too costly, too painful, too destructive, too inefficient for civilized people." And as we've all experienced over the last number of decades, it's only gotten worse from when Chief Justice Burger made those observations. Next slide. So one of the things I wanted to start with are the top 10 benefits of entertainment arbitration over court litigation. And benefit number one is that unlike a court where you really can't select your judge, and it's, you certainly have jury voir dire, but it's difficult to select members of a jury pool. Arbitrators are selected by the parties either by agreement or by ranking of a list of candidates, which is referred to as a rank and strike list. And those of you that have done arbitration before, you're familiar with this. If you haven't participated in arbitration, Aaron, if you could talk real quick about how that rank and strike list works.
Yeah, so I mean, I can obviously speak for AAA. At the start of every case, you usually have an administrative call where the parties are just communicating with the case manager, and the case manager will ask the parties kind of what qualifications they're looking for on an arbitrator. And I would assume in an entertainment case, obviously having some experience with entertainment law would be a requested qualification, but sometimes you get other qualifications like somebody who's a retired judge, or somebody who is an attorney arbitrator, but has X amount of experience as a litigator and so much as a transactional attorney and whatnot. I mean, people get pretty exotic. And then based on the qualifications that they're looking for, that case manager will put together a rank and strike list with who they think would be the best match for the case. And typically, we're able to find a match with the first list. Occasionally, we have to go to a second list, but we try to be pretty friendly about it, not limit strikes on the initial rank and strike list, and see where we can go. Of course, we're always interested in when the parties are working well together with each other, and if the parties want to, compare their lists and kind of have a conversation before they start their ranking and striking, that's fine as well. But we always like it when the selection process is mutual.
All right, thanks. Yeah, we're going to talk a little bit more about arbitrator selection in more detail later. But benefit number two, I mean, if you have an entertainment dispute, you can get an entertainment law specialist as a trier of fact. Unlike generalist judges or layperson jurors that don't have any background in either entertainment or law, arbitrators, really one of the biggest benefits, I think, of arbitration is that arbitrators are available who are subject matter experts in the industry and the type of disputes over which they preside, And we'll talk a little bit later about, different considerations in the arbitrator selection.
Can I just add one thing quickly to that, Paul?
Yeah, sure.
The importance of selecting somebody that has the requisite experience you're looking for. Yes, I get it all the time. Parties say, like, we're only interested in a judge. And I'll be like, you'll even take a judge that has no entertainment experience? Are you sure about that? And they're like, sure. And I'm like, well, probably not the best person for this case, because remember, not only will they struggle to understand some of the aspects of your case, but they're going to have to do a lot more research, and they're going to have to learn about entertainment law. And remember, arbitrators bill the parties for their time doing research and learning about a particular area of the law. So it's going to cost you a lot more money if you're using a lay person rather than an expert. Thanks, Paul.
Thanks. Benefit number 3, and this can be very important, obviously, in entertainment disputes. It's a private proceeding. So the information that is filed in connection with the arbitration, all the papers that are filed, everything that's going on is private, not available to the public. The public does not have access to the location of the evidentiary hearing. The press can't get at it. But I emphasize that it's private because it's not necessarily 100% confidential, especially if somebody is seeking to confirm a final arbitration award or seeking to vacate it, then it becomes a court case. And so it may be down the road that the subject matter of the case does become public. And we've seen in the press, a lot of cases that have reached the press, especially in entertainment, high profile cases involving celebrities and other issues sometimes do make it to the press. But benefit number 4 is that the parties can agree in the arbitration provision and otherwise that the proceeding will be confidential, and they can make it essentially subject to the equivalent of a non-disclosure agreement. So these are really sort of 2 aspects that are really important to consider, and I think are a real benefit for having disputes resolved in arbitration rather than court. Number 5, something that a lot of lawyers don't really realize and sometimes can be scared about, and feel like that fish out of water, like Axel Foley or Ted Lasso. But the thing about arbitration is that, both kind of a benefit and then a little bit scary is the procedure. It's supposed to be flexible, and it's supposed to be able to be customized for the particular type of dispute that is being arbitrated in any given case. So, and arbitrators can be more user-friendly and available and accessible than judges. I mean, there's a lot of user-friendly judges, certainly, but arbitrators are really trained and taught to have customer service and be available. And that's one of the benefits. And after all, the litigants are paying the arbitrators. And they are willing to be flexible to customize the procedures to fit the nature of the dispute. So we'll talk a little bit more about how to do that later. Next slide, please. Number 6. Now, some people may take issue with this. If you've been in an arbitration that kind of, runs off the rails, which can happen. But the research shows that the parties will get a final arbitration award much faster than they can expect to get when they go to trial in court. And arbitrators are willing to schedule the evidentiary hearing within months. And in some cases, if there's an emergency, if you have a production being held up or something like that, arbitrators are willing to fast track the evidentiary hearing. There was a study done, I think, back in 2017, and it came out showing that the average termination in a U.S. District Court case was 24.2 months versus arbitration at 11.6 months. Now, obviously, those are averages, and individual cases can differ. But generally speaking, in my 30-plus career as a court litigator and an arbitrator, the arbitrations tend to be resolved much faster. Number 7, more efficient and cost effective. Another thing that is subject to debate. I mean, we're going to talk later on about being subject to arbitrations that, maybe run amok a bit, or arbitrators billing way more than the amount in controversy. That does happen. We're going to talk about how to prevent that. But while the parties will have to pay for the arbitrator and the arbitration provider fees, it's critical to select an experienced arbitrator who knows how to manage cases and has experience with managing cases and can decide discovery disputes efficiently and handles pretrial disputes and has, some mediation capabilities to help the lawyers resolve and problem solve when they hit a snag in the prosecution of the case. And the idea is, yeah, you're going to pay arbitrator fees and arbitration provider fees, but what we're trying to accomplish as arbitrators is to encourage the savings on the attorney's fees and cost side. And that is the goal whenever I'm presiding over a case. Benefit number 8, greater finality. So final arbitration awards are indeed final, and the grounds for vacatur are very limited, and we're going to go over that a little bit later. And it's not subject to the regular appeal process, so you don't have to wait another 18 to 36 months for an appeal, to get a final outcome and, to get your judgment enforced, for example. Number 9, flexible decision-making. Again, this is something that is subject to debate, and we're going to talk about this a little bit later. Unless the parties have otherwise agreed, say in the arbitration provision, that the arbitrator must follow the law and issue remedies only a court can issue, the arbitrator under California law has more flexibility. And it's said that an arbitrator may decide a case ex aequo et bono, which means according to the right and the good. Now, some parties might like that. Lawyers feel uncomfortable with that. I mean, when I'm wearing my trial lead counsel, hat, I want to know that the person in charge is going to apply the law. And as I'll talk about a little bit later in a couple of slides, it's my experience and in my own practice, as well as arbitrators I've worked with on panels, that almost all arbitrators I've ever come across really do want to apply the law correctly. I'm sure that there's been lawyers in arbitration that have seen results that they felt, was not applying the law. And finally, benefit number 10, worldwide enforceability, which becomes more and more important as entertainment disputes go international. The Convention on the Recognition of Foreign Arbitral Awards, which is referred to as the New York Convention, provides for the enforcement of final arbitration awards in 168 countries. Next slide. So I'm going to go over a few slides before I turn it over to Aaron to address drafting arbitration agreements that deal with certain fictions that a lot of lawyers have come across, and that during my career I've been told. And I want to sort of separate the fact from the fiction. The first is, and we're going to talk about this later, it's one of the issues that Neville will talk about, but lawyers think that arbitrators allow very limited or no discovery. And while that's a statement that would be more accurate in international arbitration for a variety of reasons, in my experience after serving on hundreds and hundreds of cases, it's not really true in US arbitration, although it can vary from arbitrator to arbitrator. Now, my experience has been that lawyers who appear before me in arbitration, they're court litigators. And there is this, sort of desire to take the arbitration proceeding and make it as much as court as they can, as much like court, because that's what everybody's familiar with. Plus, everybody's used to in litigation doing discovery to prepare the case. And so, I find that lawyers generally want to prepare their case in a similar way. And in almost all of my cases, counsel will stipulate to a certain number, maybe of written discovery requests, maybe a certain limited number of depositions to take, an expert deposition. But if one party, rarely what happens is one party's attorney wants to do more discovery than the other one will agree to. And if that's presented to an arbitrator, the arbitrator really should be applying the rule of proportionality whether the benefit of the additional discovery sought outweighs the cost, taking into account the amount in controversy, the issues involved in the case, and whether the discovery is likely to result in evidence that will help the arbitrator decide the case. And you need to have a good, experienced arbitrator who's willing to keep the case under control, manage the case, and explain to counsel and get their buy-in that, you can't really do every single discovery act that you might want to do that you otherwise might do in court. Next slide. Next, fiction. Did we miss one, or let's see. Third-party discovery is unavailable in arbitration. This is going to be discussed more by Neville later on, but I just wanted to throw out there that we have arbitrators have sort of come up with, and there's a consensus in California that there's a way around this prohibition or the fact or the rulings that the arbitrator doesn't have the authority to issue subpoenas to compel discovery depositions or to compel discovery production of documents and electronically stored information. And so what I do is I have counsel, if they have a third party that is not voluntarily appearing at a deposition or not willing to turn over documents, I have counsel either make a motion informally or advise me by email and confer with opposing counsel that we will set up an evidentiary hearing, a preliminary evidentiary hearing at which that third party's testimony can be compelled, because I have the authority, the arbitrator has the authority to issue subpoenas to third parties for hearings. And so what I will allow counsel to do is to request a preliminary evidentiary hearing so that testimony can be obtained just like it would in a deposition. And then this would occur before the evidentiary hearing on the merits. But what I found is 99 out of 100 times when that subpoena gets issued for an actual preliminary evidentiary hearing, the third party will usually cooperate with attending a deposition, either on Zoom or in your office, as they would in a normal case. Next slide. Another thing that lawyers have come to believe is that there's no motion practice in arbitration. And, obviously lawyers in court cases are used to filing motions, but, for the same reason I said before, as more court litigators represent parties in arbitration, and as arbitration becomes more prevalent, and it's certainly growing leaps and bounds, if for no other reason that, A, we have international disputes where we need finality and worldwide enforceability, and B, just about every online company out there seems to have arbitration as a means of dispute resolution. So you get a lot more court litigators doing arbitration. They tend to file motions like they do in court. Some of the longtime arbitrators really discourage motion practice because, again, it's going to, increase the costs of the whole proceeding. And the whole idea is we want the proceeding to be efficient. But, I've just listed on this slide some examples of types of motions that I see filed in arbitration. And more I see motions for summary judgment or motions for partial summary judgment. And the AAA, for example, has Commercial Rule R33, which requires a party to request leave. And the arbitrator is permitted to make a ruling on a dispositive motion only if the arbitrator determines that the moving party has shown that the motion is likely to succeed and dispose of, or importantly to remember, narrow the issues of the case. So it may not, there may be still issues of fact, but a partial summary judgment motion might narrow the issues and allow the evidentiary hearing to take less time than it otherwise would. Another thing I'm seeing more of is that, when an interim award on liability and damages is issued, I see counsel requesting, both counsel or stipulating to, the right to move for reconsideration. And, in arbitration, one of the most important things to avoid a vacatur is to make sure that the arbitrator has addressed all the issues submitted. And sometimes the motion for reconsideration will say, oh, there's an issue you didn't address. And so it's probably better to have that, even though it extends the proceedings, than to subject the final arbitration award to vacatur. Next slide. The final one we have here is that arbitrators don't follow the law and they'll split the baby. And there was a survey done of Fortune 1000 corporate counsel, where it found that about half believe this. And in reality, my experience is that the great majority of arbitrators are, or they're retired and they were litigators. Most of the arbitrators that I've encountered serving on panels of 3 want to follow the law, do follow the law. I follow the law, and they work hard to determine the correct amount of the damages, which is often less than the amount that the claimant contends. And the court juries obviously often don't have the expertise to do that. And then my experience has been, and people may debate about this, but they tend to pick a side and give plaintiffs the full amount they're seeking if they're going to find in favor of the plaintiff. Or if they find in favor of the defendant, more often than not, they probably will return nothing. The arbitrator, being a subject matter expert and an experienced lawyer and everything, really wants to get it right. And sometimes in the past, that's been interpreted as splitting the baby. But it's not like an arbitrator is sitting there going, gee, I don't really know who's right and who's wrong, so I'm just going to split it down the middle, as if they were a mediator suggesting a compromise. I don't see arbitrators actually doing that in practice.
Paul, I can speak to that. I think we even have some statistics on the AAA website. We did a study on splitting the baby as a myth. It's absolutely a myth. Just for those of you out there that don't understand what splitting the baby necessarily means, let's say you're a claimant, you have a legitimate $1 million claim, you win your claim, but the arbitrator just gives you half of what you're looking for. There's this myth out there that that's how arbitration works. And it's not necessarily because the arbitrator doesn't understand the law or doesn't want to give you the full amount of your claim. It's that the arbitrator, is trying to make both sides happy somehow, and thinks that by splitting the baby, they're doing both sides a favor. There's no truth to that at all. I can tell you as a case manager, I read every single one of my cases awards before they go out. And I have seen an awful lot in the last couple of months of 100% of the claimant's claim being awarded or 0% being awarded. So very little splitting of the baby going on. Arbitrators are going to clearly define a winner and a loser in a case.
And that's been my experience as well. Nev, have you been in a case or heard about cases where you really felt there was a split the baby, and if so, could you tell us a little bit about an example?
Well, the arbitrations that I've had, I have sometimes been not happy with the result. I wouldn't say they split the baby. I think he or she got it wrong. But I think I agree with you that most of the time the arbitrator tends to get it right. There's a concern in particularly the entertainment business, particularly in net profits cases, that the arbitrator will split the baby and give a lesser award. And that's because of the so-called repeat player problem, which is with jams, because jams is in every single contract in showbiz practically. And there's only about 10 or 14 arbitrators. And there's a law review article that was written by Ron Nesson, which I cite in the papers here, that goes further into that issue. And I would say also, we haven't even talked, Kaiser has its own independent arbitration system, and they're like the biggest healthcare provider in California. And I have learned or been told by people there that if an arbitrator gives a hospital or doctor a significant kick, that person will be hired again. So that is a concern, at least in that genre.
I can say, on the claimant side, the key to getting your full claim amount, if you have a good case, is to, on your initial demand, actually come up with a realistic number. I think because the splitting the baby myth is so prevalent out there, somebody would feel they have a $25 million claim. That's a legitimate amount of money, but they might feel that they have to on their demand write $50 million because they think they're only going to walk away with $25 million if they don't ask for twice as much or something like that. That's totally unnecessary. Arbitrators like it when there's like science behind numbers and things like that, and you can get the full amount of your claim if the numbers make sense.
Yeah, we're going to talk more about that later, because that's one of the points I'm going to make later on about, you know, how to win in arbitration. And Aaron's exactly right about arbitrators' concerns about being right on the damages. Next slide. Now, this is something that I really want to highlight for everybody, because I think a lot of lawyers don't realize two things. One is that they think that arbitrators can't issue declaratory and injunctive relief. And I would say, given the fact that I tend to be selected for large, complex cases, and I also tend to be selected for cases oftentimes involving intellectual property rights or franchise and that kind of thing. And I'd say about half of my cases, claimants are requesting some sort of declaratory or injunctive relief. And many lawyers don't have any idea that arbitrators have the power to issue temporary restraining orders or preliminary injunctions or specific performance or permanent injunctions. Now, you know, using the AAA as an example, rules 37 and 38 provide for interim measures, including injunctive relief and emergency relief. We're going to talk about this. Aaron's going to address Rule 38 a little bit later, but it's a very powerful tool, emergency measures of protection, to use in arbitration. And your opposing counsel may know nothing about it. So Aaron's going to go into that a little bit further just in a bit. But in the Ninth Circuit and most other circuits, emergency interim awards, you know, as long as the emergency part of it has finality, and this is somewhat in flux, but, you know, in the Ninth Circuit, emergency interim awards ordering preliminary injunctive relief, you know, will generally be enforced by U.S. district courts. There might be somebody out there who's had a bad experience with that. I've seen scenarios where other courts, you know, thought in a particular case that, you know, the emergency award was not final enough, or they didn't have the authority to do so. So this is all in flux. But in cases that I've been involved in, I've actually seen people go to court successfully and get an emergency preliminary injunction, you know, actually enforced. And I'll come back to this and how to handle these types of cases later on when we deal with how to win in arbitration. I think that's the last fact versus fiction one we have, Kathleen, and I'm going to turn it over to Aaron.
Okay, very good. So we have here our examples of entertainment disputes appropriate for arbitration. So pretty much any entertainment dispute is appropriate for arbitration. You know, the question is always, can an outside provider like a AAA or a JAMS be the provider, or is it handled by one of the internal arbitration panels? Like a lot of the guilds, for example, have their own kind of arbitration panels. So film, television, and streaming production distribution agreements. I think those are some of the most common ones that we see. Film, television, and streaming financing agreements, you know, where the money's coming from. License and royalty agreements, talent studio agreements, actor agent agreements, artist record company agreements, and content creator agreements. So pretty much they can span a great range of different types of disputes that might arise. Next slide. All right, so now we have our best practices for drafting arbitration provisions and entertainment industry agreements and kind of my top 10 subjects. So before I kind of go into this, I'm just gonna break it down like this, because oftentimes on larger cases, I am the case manager, and the first sticking point is the parties disputing exactly what the arbitration provision says. It never makes sense to me. The older I get, the more of these contracts I read. I might have a 200-page contract, and buried in page 117, clause C2A, there's a one-sentence arbitration provision or a two-sentence arbitration provision. You've got this giant contract. Like, it amazes me that they wouldn't spend a little bit more time drafting it. So before I go into these 10, I'm going to tell you 4 things that every single arbitration provision needs to have, all right? Absolutely, you need to have what type of rules we're following. And it's not just enough to say AAA rules or JAMS rules. At AAA, for example, we have commercial rules, we have employment rules, we have construction rules, we have consumer rules. You want to say the specific type of rules. Next, parties love to argue over is it going to be heard by a single arbitrator or a panel of 3 arbitrators? At AAA, the 1 versus 3, if the clause is silent, is based on claim amount. But you can imagine, in the spirit of arbitration being faster, more cost-effective, that etc. 3 arbitrators is going to cost a lot more than 1 arbitrator, and it's not just 3 times as much. In our studies, it's 4 to 5 times as much because the chair of the arbitration has to supervise the other 2. So, type of rules. Address the 1 versus 3 issue. Please use the words single or 3. Do not think arbitrator or arbitrators, plural, necessarily determines that, because courts have gone both ways on that. All right, the next thing commonly thought about is the location of the arbitration hearing. Now, I understand, also commonly referred to as a seat. I understand that a lot of these hearings are now taking place virtually, and people might not think the site of the evidentiary hearing is important, but it is, and there should still be a location. So you want a city and you want a state. If it's in a different country, the city and the country, whatever it might be. Do not put 2 different options in your contract that are completely different cities and completely different states, because the parties will fight over that, and that's just going to make the process more drawn out and more expensive. Last but not least, there should always be a governing law or choice of law provision. Under what state's arbitration and contract laws will this provision be governed by? You're going to have 2 different parties in 2 different states. Each party is going to argue that their state's law applies. Let's have that all worked out in the arbitration provision. So those are the 4 things that you need, just at a bare minimum, to have something make sense. And sadly, the vast majority of arbitration provisions I see do not have all 4 of those items. All right, so arbitrator provider, rules to apply in arbitrator selection process. Once again, that makes everything smoother if we have that all spelled out. Arbitrator qualifications, obviously we're talking about entertainment arbitrations today. You might say somebody that has 10 years experience arbitrating profit participation disputes or disputes between talent and their agency, something like that. Is it going to be a sole arbitrator or a panel of 3 arbitrators? Once again, a panel of 3 arbitrators will be 4 to 5 times more expensive than a single arbitrator and will take a lot longer typically to get through the process. Governing law, choice of law provision. The locale of the arbitration, the seat of the arbitration. Confidentiality. So the presumption in arbitration is that arbitration is private, but there are going to be interesting situations that arise where potentially an award will have to be made public, or at least explained to somebody. I had a case, for example, where a large publicly traded company received a $175 million arbitration award. And depending on the size of the company in the industry, $175 million is a lot of money or it's not a lot of money. I don't know. But this company said that they couldn't have that amount of income coming in without explaining it to their shareholders where it came from. So they needed to have an exception to the confidentiality provision for that. And both sides really like to fight over that. Discovery. I've seen some arbitration provisions that are like, listen, this is an arbitration provision for a relatively small case. Let's say if you're dealing with a case that's under $500,000 or something like that, we're not going to allow depots, or we're going to allow 1 depot from each side or 2 depots from each side. Depositions take up a lot of time and they can cost a lot of money. Remedies, including emergency relief, we're going to talk about that later. The assessment of attorney's fees and other costs of the arbitration. So this would be like a prevailing parties clause. Does the side that wins get to collect attorney's fees and the cost of the arbitration? Maybe they do, maybe they don't. And what type of arbitration award are we going to have written? On a small case, it might make sense just to have a simple award. This is the winner, this is the loser, these are the numbers that are going to be awarded. But on a large, we'll call it large complex case, LCC track, you probably want a reasoned award where it could be 10, 15, 20, 30, 40 page long award where the entire thought process that the arbitrator came to get to those numbers is explained. Obviously, a reasoned award is going to cost a lot more than a simple award because the arbitrator had to take the time to draft it. Next slide. All right, poorly drafted arbitration clauses result in, well, lots of problems what they result in. So failure to meet the parties' expectations. So what are the parties' expectations? That arbitration was supposed to be a faster, more cost-efficient way to resolve a dispute than going to court. Sometimes that's true, sometimes that's not true. There are unfortunately some parties that have found ways to game the system and to make things more expensive and complicated than they need to be. Again, if these things are properly explained or pre-planned out in the arbitration provision, then we can avoid a lot of these headaches. Costs that quickly spiral out of control with the advantage going to the side that has more money to spend on the process. This was never supposed to be the goal of arbitration. Arbitration wasn't supposed to be the party with the most money wins the arbitration, all right? It's supposed to be like a court of law almost, right? Fair, justice is blind, neutral. But unfortunately, that is not always the case. And typically the side with more money, what their goal is to force the side with less money into some sort of a bad settlement agreement. Basically saying, listen, we'll keep this case going as long as we have to and file as many worthless motions and ask for all sorts of discovery things that we probably don't need just to financially bleed you out. But I tell you what, if you want to do a mediation tomorrow, we'll come up with a number and we'll wrap this up real quick. That's not the way it should be. Unnecessary court intervention. Anytime the court has to get involved, it's going to cost a lot of money and it's going to be a big headache. Things that we kind of typically see the court getting involved with is if an arbitrator is trying to attach maybe a third party that may or may not be a party to the contract into a case. Questions regarding locale that the parties are still fighting over. Sometimes a party might go to court claiming the arbitrator is not following the provider's rules. That never seems to work, but we see silly stuff like that from time to time. So there's all sorts of reasons a party might run to court. But usually the courts defer to the FAA, the Federal Arbitration Act, which kind of governs all arbitration and kind of rules in the arbitrator/arbitral provider's way. Rarely does the court disagree with what the arbitrator is doing. And then the arbitral process itself being blamed for an unfortunate result, not the poorly drafted arbitration clause. Like I said, arbitration is supposed to be a faster, more cost-efficient way to resolve disputes. And when that doesn't necessarily happen, people tend to get pretty upset. All right, next slide. All right, so like I said, this isn't a commercial for AAA. You're welcome to use whatever provider you want, but AAA has come up with this tool called clausebuilder.org. This is a free interactive service. Everybody can go to the website right now if they want to play around with it, where you'll basically be asked to answer a series of questions about your arbitration, and you can come up with a really comprehensive, bulletproof arbitration clause that hopefully, will alleviate a lot of the problems, at least preliminary problems that we run into when we have arbitrations. Like I said, it's free. We're not tracking you. You're not going to get spam. You don't have to register necessarily with a email account or anything like that. And you can just go through the process and just copy and paste the clause that you've created and put that into whatever contract you want. It's pretty simple. Next page. All right. So this is a standard arbitration clause. This is not this is kind of the nightmare clause that a lot of people that don't put any thought into their contracts use. Basically here, it just kind of says that if there's any issue that comes up, it's supposed to be settled by arbitration by the American Arbitration Association, and any court having jurisdiction thereof can enforce it. This does not discuss the 1 versus 3 issue. This does not, give me a locale. This does not talk about choice of law or any of that kind of stuff. So this is the kind of clause that's going to get you into a lot of trouble. Next slide. This is an example of what we call a multi-step arbitration clause. The difference between this one and the last one is this actually requires a mediation step first. Now, quite controversial in the arbitration world. Should you require a mediation to take place before an arbitration can even be filed? I'm a big fan of mediation. I love mediation. I love mediators. I think it's a great way to resolve disputes, especially if you have a really good mediator. I can tell you in my experience, unless both sides have done a little bit of discovery in the case and they have the amount of information they need to make a good settlement decision, it can be a waste of time doing an early mediation or having an early neutral come in and evaluate a case. You want the mediation to take place when the case is ripe for the mediation. That way you guys can, reach a settlement. It doesn't have to necessarily be a formal mediation. You could change the language in this clause here to just basically say that the parties need to spend a certain amount of time, let's say 30 days, having informal settlement discussions before an official arbitration case can be filed, and to make sure that there's no way that they can come to an agreement before that arbitration is filed. Next slide. Okay, so this is one that I like, right? So it has the location, has the number of arbitrators, has the choice of law, and has the list of qualifications for the arbitrator. This is a great arbitration clause. If you put this in your contract, you're going to avoid a whole lot of problems. So highlight this one as a good one. Next slide. All right, so for example, you can add pretty much anything you want to a arbitration provision. So this one is discussing discovery provisions, how the exchange of documents, electronic discovery, whatnot, proportionality rule, and other items related to discovery. This is going to help the parties kind of get a better idea of what's allowed in discovery and what's not, and hopefully lessen the number of discovery disputes that have to be brought up to the arbitrator. Remember, anytime the parties are arguing about something in discovery and have to get the arbitrator involved, the arbitrator is going to bill them for that time. So this is one way to kind of cut down costs. Next slide. Exchange of documents, limited deposition. So we talked about this, I think it was in slide when we were going over the top 10 things that you should have kind of in your arbitration provision, deciding whether you want to allow depositions or not, and how many depositions to allow. The vast majority of arbitration provisions I see do not talk about things like this. And so if there is no limit on depositions discussed in the arbitration provision, then ultimately it'll be up to the arbitrator that kind of decides how many depots each side should be able to take and kind of the length of those depots. Usually these items will be discussed with the arbitrator on the preliminary hearing call, which is the call the first time the parties are talking to the arbitrator, and the call that sets out the scheduling order, or at least the initial scheduling order. Next slide. Court style discovery. All right, so a common thing that parties like to argue about is what rules exactly apply to discovery? Are we following just the federal rules? Are we using the California Code of Civil Procedure? Are we using federal evidentiary rules? Are we using California evidentiary rules? Are we using some other states? So if you can put this into the arbitration provision, you're going to cut down on headaches later on. Next slide. All right, so an example of arbitrator remedy provision options, another area of infighting happens to do with all sorts of exotic types of damages, exemplary damages, punitive damages, treble damages. I mean, people come up with all sorts of damages on top of what their original claim is. And sometimes arbitrators award these, sometimes they don't. But if it's clearly explained in the arbitration provision what the arbitrator can award and what they can't, it's really going to cut down on problems later on. This also has a prevailing party clause that we talked about. That could award, the arbitrator shall have the authority to award fees to the prevailing party, regardless of whether there is a prevailing party to allocate costs of the arbitration process among the parties. That's an interesting little line in there because regardless of whether there is a prevailing party. Something to remember if you're not very familiar with arbitration is there can be situations where there is no prevailing party. So this gives the arbitrator still the power in that situation to award those costs. Next slide. All right, emergency measures of protection. So what is emergency arbitration? What are emergency measures of protection? So in certain situations, one of the parties, usually the party bringing forth the emergency action, doesn't have time for a traditional full-blown arbitration to go through the entire process to get an answer. Usually this is an emergency situation where one side needs some immediate injunctive relief because the other side is doing something that's causing them immediate and continuing harm. I'm just going to give an example outside of entertainment, kind of where I see this. Let's say you're a seller on an online sales platform. Let's say the online sales platform thinks that you're being mischievous or somehow hurting customers or not being fair, and they decide to suspend your seller account or something like that. Well, let's say next week is Black Friday or like a really busy shopping day, and you need some sort of at least temporary injunctive relief to get yourself back on the sales platform so you can start selling your stuff again, at least over this period while your full-blown arbitration gets to play out to decide whether or not you should be kicked off the platform, which could take, months or maybe even a year or more for an arbitrator to make that decision. Paul, I'm going to bring you in here kind of with your thoughts on emergency orders of protection, especially in an entertainment context.
Yeah, it's something that I was going to address in the top 10 winning tips. So we can defer that if you want, or we can talk about it now, whatever you prefer.
Yeah, I think we can talk about it later. I want to kind of keep moving along, and I know there's a lot of stuff to say on his section. So we'll go to the next slide. All right, they can advance through this slide too, but like I said, typically these are things that can be added to an arbitration provision. Okay, so here, what we have here is I've given you guys some examples of different arbitration provisions in Arbitrator, and these are actual contracts. Obviously, I've taken out any identifying information so you don't know who the parties are. But these also happen to be some of the most common disputes that we see with arbitration provisions. So this one is a dispute over net profits for a motion picture between a production company and a distributor. All right, obviously this is a very type of arbitration provision. Obviously, I'm not going to read this to you all word for word because that would just be a waste of everyone's time. But I encourage you to look through the materials in the PowerPoint from studying some experiences. Next provision, next slide. All right, so this one is a dispute between a TV producer and a production company / distributor over modified adjusted gross receipts derived from a television series. All right, so like I said, again, a different example of a clause. This one actually has a, looks like it'll be a panel arbitration here. You can see kind of in the middle of the clause, it says within 10 business days thereafter, the other party shall designate a second arbitrator in notice. By notice in writing, duly given the agreed party. So it kind of goes over a timeline for appointing arbitrators and kind of a process. Obviously, it has a seat in here. It says shall be held in Los Angeles, California. Also has a choice of law provision here. The governing law here is confirmed under the laws of the state of California. So this is a pretty good clause right here. Next slide. Okay, we have here a dispute regarding a breach of partnership agreement over a film formed as an LLC. For some of our more junior attorneys on the call here, it is very common to form an LLC as basically the company that your movie is. So it might be the name of the movie, LLC. And most LLCs have investors, and those investors each own a share or shares of the LLC. So basically partnership agreements or in entertainment or not in entertainment are very commonly have an arbitration agreement in them. Next slide. All right, dispute between a music distributor and recording artist over a recording artist backing out of exclusive recording contract. So not just film and television and streaming, but obviously we have music contracts here. I thought something was really interesting in this one. If you go to the second half of the clause, it says, notwithstanding the foregoing, if a third-party claim is brought against distributor for copyright infringement violation of rights of publicity, rights of privacy, or other unauthorized use of content which is contrary to the rights granted by artist to distributor in this agreement, distributor shall not be bound by this arbitration provision and may defend itself and make a claim against artist in the appropriate court of law and or equity. So basically, this is, artists are constantly sampling other artists' music, and they're supposed to get clearances for all that kind of stuff, not just basically steal other people's stuff. And this is basically saying if the artist goes ahead and steals something from another artist, and the distributor somehow gets tied into a lawsuit, the distributor can take actions against the artist in regular court. So I thought that
let me say something about that. That is a very one-sided clause, which I think would work against the distributor as well, such that this clause might be a nullity if they can unilaterally say, oh, we're going to the Superior Court or the federal court. Why couldn't the talent then just say, well, if it's going this way? It's like a typical, the old rule that if you have a one-sided fees award, the court says it works both ways. So I'd be careful about this.
Yeah, no, Neville brings up an interesting point. This is kind of like, for those of you that are following these mass consumer arbitration cases, where, there's a class action waiver. So law firms are just going out there and finding plaintiffs to file thousands of individual consumer arbitrations at the same time to make it very hard for the respondents to pay for things. There was some talk that companies would simply, because they rewrite their arbitration provisions at the company's option, say it'll either stay in arbitration or parties have the right to form a class and proceed against them in that way if it's going to be cheaper for the respondents. I don't think any of that's going to hold up in court. As Neville mentioned, the contract has to go both ways and the arbitration clause has to go back both ways. So that's an important point that Neville mentions. Next slide. Okay, we're going to go back to Paul. Thank you, everybody.
All right, thanks, Aaron. I'm going to try to get through these top 10 tips for winning your entertainment arbitration cases really quickly. In drafting the PowerPoint slides, the idea was to allow you to be able to go back and look at these for reference. So I'm obviously not going to read them or cover every single thing on the slides because, like as if we were doing a concert at Hollywood Bowl, I want to make sure there's enough time for the headliner, Neville, who's going to talk about, I think one of the most important parts about this seminar, and that is, dealing with issues in arbitration that can be problems. And it may be the case that some of the things on these winning tips, might foreshadow some of these things. So I'm going to try to go through them quickly, and please forgive me if I leave anything out. We're going to try to, answer some questions. So put questions in the Q&A if you have any. Next slide. And these tips I've sort of developed as a combination of my 17 years of experience as an arbitrator. Like Kobe, the AAA recruited me when I was in high school. So, I've had 17 years. And I can't look at the crowd and see whether or not that's a joke that bombed or not. But in any event, over the years, I've kind of developed these thoughts about, what lawyers can do to help to win and what lawyers don't do sometimes that, can hurt them. So one of the things is that because arbitrators today, at least, are all mostly litigators, that doesn't mean you have to be a litigator to be an arbitrator, but most of them are. And most of us spent, 20 years, 30 years, whatever, litigating in court. We're used to looking at court pleadings. Now, the demand for arbitration of most of the providers is a very simple form, usually a 1 or 2 page form, has a real small space to describe the nature of the dispute. And it doesn't really, it works great for more simpler cases. Again, we won't really want to keep the cost down for the low dollar cases. But because I see more and more and more multi-million, even cases involving tens of millions of dollars, with major law firms appearing on each side. I see a lot more of court-style pleading, and quite frankly, I would, in a large case, encourage counsel to do so. And that is, in addition to the form of the demand for arbitration, which could be filed initially, the idea would be either at the time you file that, or at some later time, and maybe there's a deadline to do so that is implemented in the preliminary scheduling conference. You file a statement of claims, which is, allegations by paragraph, just like a complaint, your causes of action, your prayers for relief. And let me underscore this very clearly. It is essential to be specific as to the damage amount and or other remedies you are seeking. And that's because the arbitrators, even throughout the case and during the case and everything else, and when they're deliberating and when they're writing an award, are going to go back and look at your pleadings. So it's very essential. Now, of course, you don't always know what the amount is at the outset. And another little thing that happens, and I'm sure Aaron's experienced this a lot, where somebody puts a low amount or some uncertain amount because they want to pay a lower provider fee, administrative fee. And then later on, I begin to find out that the case involves, $10 million more dollars, and then that requires an adjustment in the payment of the administrative fee. But most importantly, the real reason for what my advice here is so that the arbitrators know what you're asking for, and you'd be surprised how frequently lawyers are unclear about that. Answering statement. Now, the rules say that an answering statement is essentially optional because if you don't file one, you deny all the claims. Always file an answering statement and set forth all of your affirmative defenses. There has been a case out there that, that addressed the issue of an affirmative defense being raised, at the evidentiary hearing. It wasn't pled earlier on. And then you get into the problem of not giving sufficient notice, an opportunity to be heard and prepare to the claimant. So I like to see answering statements that are like answers in court with all the affirmative defenses that you want to assert. It's possible that, an arbitrator may rule, or a court later on down the road may rule that you waived an affirmative defense if you don't assert it. Especially something like statute of limitations. Counterclaims, I would say that, follow the same rule as the statement of claims. And just the point is that arbitrators do pay attention to pleadings when deliberating and deciding a case. It's also important as well for me as an arbitrator, especially if I'm a chair of a panel, to know the amount in controversy. I have a case going on right now where there's a low amount of controversy that was asserted. And then in the preliminary hearing, the respondents counsel told me that, the other attorney in other discussions was claiming much more. And, I have a panel, and, a lot of the way that I'm going to, manage the case depends upon the amount in controversy. Obviously, I don't want there to be arbitrator fees that, are 50% or, some substantial percentage of the amount in controversy. But then what happens later on is we find out that a greater amount is actually sought. I'm not going to go through and spend a lot of time here going through. This is more of a list for you to take with you. And that is, I can't overemphasize, if there's anything on the next slide, by the way, you can go. I can't overemphasize this point. If there's anything you take away from this, it's give a lot of thought to arbitrator selection. Arbitration can be a great process, way better than you've ever experienced in court, if you have the right arbitrator for the case who has sufficient experience. And it can also be a process that's not as good if you don't. So the one thing I want to emphasize on this slide is think about the number of years that the person has served as an arbitrator, the number, they don't always say the, number of prior arbitrations, and the frequency of service as an arbitrator, because, like I know people that have been arbitrators on panels for 25 years, but they only do one case every 4 or 5 years. and they're not necessarily familiar with arbitration procedure. They're not necessarily familiar with arbitration law, the statutory and case law that's involved. And that can, make a world of difference to a good, fair experience versus one that's, not as good. And some of these are some of these items are obvious, but certainly in an entertainment case, it's going to be helpful to have subject matter expertise. We're seeing an expansion in entertainment disputes. We're seeing entertainment disputes, involving digital content, social media, non-fungible tokens, things we haven't seen in the past. And it's going to be hard to find, arbitrators who have had experience or know something about the terminology. It's also really important for that arbitrator to have management and people skills. You might have an arbitrator that was really a great trial lawyer. Maybe they've been practicing for many, many, many years, but for some reason you put them in the role of arbitrator, and the attorneys kind of run amok in the case, and they don't necessarily, manage it all that great. And you have to have somebody who's thinking about cost, thinking about efficiency, has the experience to make a decision, is proactive rather than reactive. What I do in a lot of my large cases is I have case management conferences with some level of frequency to keep everything on track and to make sure that people aren't doing things that they don't need to be doing, and to try to keep the costs down. Now, yeah, everybody's got to, pay me for an hour at the case management conference, but I'm trying to save them thousands, tens of thousands in fees by moving the case along, making sure that it goes forward when we scheduled it, so that we don't have these constant continuances, which is the biggest thing that causes arbitrations and court cases to go out of control with attorneys' fees and expenses. Somebody who's got mediation skills is great, because lawyers always have disputes, and sometimes those disputes are kind of silly. And if you have mediation experience, you can persuade the lawyers to stipulate. And I think that's an important part of keeping the case going and making sure it's efficient, and trying to reduce the number of pre-evidentiary hearing disputes.
Can I just add something real quick to that, Paul?
Of course.
Yeah, so this might come as a surprise to some people, maybe not, but something like a AAA 75 to 80% of large complex cases, meaning cases, with a claim value, let's say $1 million or more, will settle before the evidentiary hearing. It is not the rule that everything goes to an evidentiary hearing. In fact, in my experience, sometimes the larger the dispute and the more dollars that are at stake, the better chance it has to settle. And we always encourage that here. We think that if the parties can come to their own resolution, that's going to be the best situation for all parties. And whether that's the arbitrator scheduling a mediation somewhere in the scheduling order and putting a deadline for that, or the parties doing it on their own, it's all very positive. We do not encourage our arbitrators to also serve as the mediator on any case, because as you know, in mediation, things are disclosed in an ex parte fashion, typically with the mediator, that the other side can't hear. And that creates a conflict if we have an arbitrator that's hearing things from one side and not the other. But certainly, mediation done by a mediator other than your arbitrator is highly encouraged during the course of your arbitration. Thanks, Paul.
Yeah, and I'm glad you clarified that, because what I'm talking about here is somebody that can help counsel settle procedural disputes in the arbitration. And oftentimes that's how they successfully get resolved. There's a discovery dispute, and essentially there's a compromise about how to resolve it. So I'm glad you clarified that. To me, as an arbitrator, the most important thing to me, there's two, and that is, one, that my award does not get vacated. And number two, that everybody that participated feels that it was a fundamentally fair proceeding. And a close number three is I'd love for everybody to feel like, hey, this was actually a lot better than I thought it was going to be, and it was actually better than court usually is. But making sure that the arbitrator is somebody who can inspire trust and confidence in the arbitration process, and listen to people, be respectful of their cultural diversities, not gaslight anybody, not railroad, or intimidate anybody, and make sure that everybody feels that this is a fundamentally fair proceeding. Next slide.
Paul, just to be aware of your time, it's 1:35 now, so just.
Yeah, I was just gonna say that I'm not gonna go over a lot of these slides, but I want to focus on the tips. It's very important for counsel to prepare for and actively participate in the initial preliminary hearing and scheduling conference to ensure that the schedule and procedure is customized to the needs of the case. Too often I see counsel that, they haven't met and conferred before, they haven't thought about anything, they don't even know when they want their evidentiary hearing, they don't even know how many days they need. And then, I have to kind of send them back to meet and confer and then come, and propose a schedule to me. So a lot of what you'll see on these slides under the heading of the winning tip are going to be self-evident when you read them. Next slide. It looks like a duplicate there. Next one. Actually, it's just listed. What I'm listing here for you to take with you is examples of issues that are discussed at the preliminary hearing and scheduling conference. Next slide. Winning tip number 4, given that entertainment and copyright disputes often require emergency injunctive relief, always consider implementing AAA Rule 38 emergency interim measures of protection. And so what happens here, I've been appointed as emergency arbitrator many times. The first one I was appointed to was not long after the rule was made mandatory. And in fact, it had to do with supercomputer equipment that mined cryptocurrency. And millions and millions of dollars were going to be lost if the company buying this equipment didn't get the equipment when they were supposed to get it. And so that was the first one I did back in 2013. This is a process that can give you a great tactical and strategic advantage. And another thing it can do is it can help you to fast track the case. Oftentimes when I'm an emergency arbitrator, the counsel will say, well, we'd really like to just go to the evidentiary hearing on the merits as soon as possible. And then they will appoint me, which they can do, as the permanent arbitrator. And then I will schedule whenever they want, whether it's a month or 6 weeks or whatever, as soon as possible, the full evidentiary hearing on the merits, assuming that they got the discovery and they're ready in their view. Next item. Next slide. Number 5, be aware of the grounds for vacatur. And if you think that the arbitrator is making a decision or failing to make a decision that could give rise to vacatur, bring it to the arbitrator's attention. Now, the main things from this slide I want to talk about. Evident partiality is kind of an obvious one where there's a failure to make a disclosure about some sort of affiliation. I think Neville's going to talk about that. Misconduct in refusing to postpone a hearing or refusing to hear pertinent and material evidence. Keep in mind those items. And the last one can essentially include failure to decide all issues submitted, deciding issues not submitted, and or awarding remedies precluded by the arbitration agreement. Next slide.
Paul, I got to get going for my part. I've only got 20 minutes left.
Yeah, why don't you do that? Yeah, go ahead.
So I don't need any of these slides up. I have some deep concerns about arbitration overall. I'm not opposed to it, but I am really offended at the costs that can occur. Before I get into it, I want to mention the Axel case, which is in the materials I provided, which was adverted to at the beginning of this. This is a case 2020 out of the Court of Appeal in Sacramento, which says that unless the arbitration agreement provides for third-party discovery, you're not going to get it. That's going to be a wipeout for a lot of people in a lot of cases. So what that means is you must put in every arbitration agreement the right to have third-party discovery overall. And that also means that all of your clients with arbitration agreements need to look at this to ensure that it's not retroactive. In other words, that agreement will need to be amended overall. And I think if you don't put the right to third-party arbitration, you're going to commit malpractice. And lawyers are easily blamed overall. Okay, pros and cons of arbitration. If you're an entity, you want arbitration. You want it confidential, you want it private, because you want to eliminate precedent overall. That's why every single agreement with every major studio says you will go to arbitration with champs. And that's fundamentally unfair. But the reason they want that is they don't want to know if actor A made a boatload on a particular movie and actor B, who was also on that movie, has additional claims. And I've actually had a case where I represented somebody on a hit show who was a creator, and the arbitrator, excuse me, the royalty auditor was not allowed to tell me what he discovered in connection with the other creator on that particular show. So it's called hide the ball overall. Arbitration, if it is inexpensive and or relative to the what's at stake, and it occurs quickly, is fine, as long as you can trust that arbitrator. Sometimes you have what are called judicial references, in which the award can be reviewed by the superior court, and that may be advisable. Note that the labor code has, says you cannot require somebody to sign an arbitration agreement as a condition of employment. This is my big concern. We had a case recently worth $150,000. The arbitrator charged $45,000. My fees were over $200,000. Opposing counsel $300,000 plus for 2 lawyers. An outrage overall over that kind of money. And that arbitrator says, "I'll give you a deal. I'm only charging $450 an hour." Another recent arbitration, the arbitrator is charging $2,000 an hour and demanded $60,000 to have the arbitration hearing overall. So how do you limit the fees? You can say, I will only go with an arbitrator who's not going to charge more than, say, $500 an hour. We'll see if there are, I'm sure there are plenty of arbitrators who will do that overall. And I want to say also, with respect to entertainment arbitrators, yes, there are some, but it is woefully, there are not enough overall, in my opinion. There's a lot of generals out there, retired judges and good people, but there's, I don't think, enough people with experience. And so I encourage AAA to get more overall. And also, let's be aware of the costs of filing an arbitration. I just filed an arbitration with AAA. It was a $16,000 filing fee because it's a sliding scale based on the amount that's in issue overall. So take a look at who's charging what and decide if the freight can be carried. Related to this as well is what happens if you have somebody who's signed to an arbitration agreement who can't afford the arbitrator? Is that a violation of due process? Under the famous Armendariz case, the Supreme Court of California said the employer is going to have to pay for the arbitrator overall. And I'm saying not just in an employment case, arguably in every case. There's not a lot of authority on it so far, but you can expect these claims or these demands to be made. In which case, what's the remedy then? The remedy then is that the person wanting arbitration pays for the arbitrator, maybe gets it on the back end if he or she prevails, or you go to the superior court, which is not the end of the world for me. And I want to mention also about the fees of arbitrators overall. I put in here, I talk about IFTA in the materials I provided. Now, IFTA is the International Film and Television Alliance. It is what is used, the IFTA arbitrations in virtually every distributor agreement for indie films. And I put down that the arbitrator, they limit the arbitrator to $750 an hour. That's wrong. It was a typo. It's $450 an hour, which is a good thing. And IFTA used to administer its own arbitrations. Now AAA has it. Okay, that's fine. But IFTA also has a clause that says you cannot sue for punitive damages, but you can in the superior court as well if you want. So who needs that? I haven't seen it happen yet where you file for an arbitration and then also a simultaneous one for punitive damages, I guess you have to wait to see how the arbitrator awards. So it seems a little unwieldy. You might want to, I loved hearing from Aaron about the $100,000 case that AAA has. I wasn't aware of that, where for $1,200 you can get some justice. I think that's great, and you might want to consider putting that in every clause. But what if it's sometimes you might have a dispute that's worth $15,000. I say in those cases, you ought to have a clause that says you can go to small claims court, just get it out of the way. But it's not worth enough overall. I consider also drafting arbitration agreements that do not permit the award, the arbitration to cost more than a certain amount in costs overall. Maybe you can get the arbitrator to agree, saying, look, this is a $25,000 case. That's all we're going to pay. We're not paying more than that. Do you agree to do it for that? I haven't seen that yet, but in writing and thinking about this, it occurred to me that would be fair. I mentioned the Monster Energy case that was a Ninth Circuit case in 2019. This is what happened here was the arbitrator owned a piece of Jams, and he did not reveal that Jams had administered, get this, 97 arbitrations for Monster Beverage over the previous 5 years. Well, obviously that's an important consideration to have known, but suppose you're not a member of an owner of Jams, I think about a third of them are, then you don't have to disclose anything overall. But you do want disclosure, and I have tried in the past to find out from the arbitrator or the arbitrator organization. I want to know, how have these arbitrators ruled in the past on similar cases? They will tell you if they've ever had a case with the same parties involved, but they won't tell you if they have habitually ruled in favor of the studios overall. That's just a problem. And you could require that the arbitrator must give full disclosure of their awards, even if they don't name the parties in previous similar situations. Now, I think that clients need to be given informed consent about the pros and cons of arbitration, and that it may be malpractice if the client is not informed in writing of the potential costs of the arbitration. I had a client recently who came to me and said, I just can't afford the $40,000 overall. So a settlement had to be effectuated in that situation. And then there's the question of the 3 arbitrators. It better be a really, really big case to have 3 arbitrators. It's just, otherwise you're paying $2,500 an hour or something like that. In another case I'm involved in right now, I'm coming in having to do with a dispute that's really, I don't know if it's part of the arbitration. It's a fight over attorney's fees. The arbitrator charged $300,000 for that particular arbitration. So, it's a great business for arbitrators, and most of the arbitrators I'm aware of are righteous and fair and smart and want to do it overall. The biggest interesting case in showbiz about 3 years ago is the Bones case, which was a Jams arbitration, and there the judge awarded about $30 million in compensatory damages and $100+ million in punitives, and ultimately there was an appeal to the Superior Court to confirm it, where they argued that there shouldn't be any punitive damages, and the trial judge went along with that. Then it was appealed further, but they settled in the interim overall. So that goes to show you that in some situations, in many situations, there may be an arbitrator who has the steeliness to award what a jury might award in that particular situation. In terms of presenting the case overall, that's the other thing. It's like, you got to find an arbitrator who, you've got a $150,000 case. Let's get through this. I was in a case involving net profits, and the arbitrator allowed motion after motion after motion to the point where the parties just said, hey, you know, this person's got to go. He's churning the case overall. And we were able to settle it. But there should be, when I went to law school, I thought arbitration was, it happens in a couple of days and it's the rules or whatever is fair overall. And to some degree, I'm all for that. But with all of the discovery has got to be in relation, as Paul was talking about, has got to be in relation to the amount that is at stake overall. And another thing is that let's make sure it does happen on a speedy basis when you file for an arbitration, and it's all over in 90 days, something like that. Otherwise, I go to these arbitrations and they last a year with people having vacations and wanting to make motions. That's another point too. I have intransigence on the other side in discovery, and I have to make these motions to compel, which is just as tedious as they are in the Superior Court overall. That lawyer who wouldn't give me that information should be punished, and the arbitrator should do that. But I find arbitrators are kind of laissez-faire, and they don't want to get too many upset, or they say we're going to deal with the end of the case. And so in those cases as well, and if there's insurance on the other side, they're going, hey, no problem, I'm going to run up a bill on this particular case. So those are my issues overall. And we actually have arbitration clauses in our fee agreements because we want confidentiality and privacy. And I recommend that for attorneys overall. But be mindful of that. Also, I think it was both of you, Aaron and Paul, you both mentioned venue clauses. I think you have to be really careful to ensure that you are in your hometown. You never want to have to travel outside of your jurisdiction overall. It just costs too much and you're going to get hometown ordinarily. And yes, it should be California law is going to be applied. And yes, it's, as I said before, it should, we put in the California rules of civil procedure or what controls discovery overall. So with that, I rest.
All right.
All right, very good. And like I said, a lot of the things that Neville discussed now, problems and whatnot with arbitration can be remedied with a solid, well thought out arbitration provision. One thing that Neville mentioned that I have seen in arbitration clauses, although quite rare, is the option of if the claim is in the amount that whatever state choice of law provision you have would qualify for small claims court, that the arbitration provision shall not apply and the parties shall handle their dispute in small claims court. I've seen that before and that makes a lot of sense.
Or limited jurisdiction, which is 30 grand, I believe. I'm not sure. I think that's.
Yeah, I don't know the exact number.
And I wanted to say, I think both of you discussed mediation as well. I had a case recently that had an arbitration clause. The clause said that my client had to meet with the decision makers of the other company. And that turned into an arbitration overall, and that turned into a settlement. So I'm not opposed to a mandatory requirement of arbitration at some point. And I think you made a very good point that, hey, if the mediator becomes the arbitrator, that's a conflict overall. But on the other hand, if the mediation is going pretty well and both sides trust the mediator, hey, let him decide or her decide.
Yeah, on that last point, there was a neutral that passed away recently, but a longtime entertainment neutral, Gerald Phillips, I believe his name was, who really pioneered Mead-Arb in entertainment disputes. Because as Neville said, you know, if you're in a mediation or if you decide that you have somebody you can trust and there's a couple of issues that are still left over, the parties can always decide to do that. I mean, what Aaron said is the general rule, of course, but, you know, the exception would be if it's a small matter and, you know, it'll be a lot cheaper to resolve. A couple of other suggestions on the cost issues, which is definitely something that, you know, everybody is concerned about. And that is that, you know, as Neville was alluding to, the default with the AAA right now is $75,000 or less. The arbitrator fee is going to be $1,200. Now you can agree, you can actually in your agreement seek to raise that. If you do an agreement and you're thinking about, hey, these are going to be kind of smaller, dollar matters, you theoretically can say the expedited procedures of the American Arbitration Association will apply up until 200,000, 300,000, 400,000, 500,000. I can assure you as an arbitrator, I mean, this is a real big thing for me. I mean, I'm aware that as a lead counsel, as a lead trial lawyer, I've experienced all these things. And so, I've always been open to, doing these cases or having a cap on the fees or a flat fee or a lower hourly rate. But I think it's true that, sometimes if at the outset, you're concerned about this, if it's raised with the case manager, right, Aaron, will do everything they can to try to address it and, select an arbitrator who will be mindful of the cost or agree to a cap or a lower amount. Isn't that right?
And that's correct. And the case manager, at least the cases that I manage, it's a parties driven process. So for example, if it was a situation that called for 3 arbitrators to hear the case, I will always give the parties the option. I'll say, like, listen, this is a $200,000 dispute. You guys are welcome to stipulate to using a single arbitrator instead of going with the 3 that your arbitration provision requires. Sometimes parties agree to that when they're getting along and things make sense. But you're right, there's always going to be that one party that wants to make the process extremely difficult and has a ton of money to throw around in this, and they might say, no, we think we need the 3. Then my hands are tied because that's what the provision said.
I have a couple more points to make, which is sometimes we've just put in the clause in the contracts that says you can pick. It doesn't. We don't require any particular arbitration administrator. We just say we're going to go to arbitration and we'll pick the arbitrator. And if we can't pick the arbitrator, we'll each pick a third party who will pick the arbitrator. You can also, and I've had that particularly in settlement agreements, where look, somebody has to decide if there's a dispute over the settlement agreement, then this particular judge will do it, and if this judge won't do it, then this backup person, and if not, then it'll go to this administrative entity overall.
One other point that Neville made that's a real frustration for attorneys, and I want to address this too very quickly, is that motions to compel, it shouldn't be happening in arbitration. There should be a very streamlined way to deal with, and this is what I put in my scheduling orders. I have a very streamlined way of dealing with discovery disputes. I will deal with it within 2 to 3 days. I'll want to hear both sides or have them jointly present their positions on it, but I'll deal with it immediately. And under the AAA rules and under the rules of the other providers too, there are sanction and enforcement powers that I have. I actually, if a party is failing to comply with my orders in discovery or otherwise, I can actually implement a dispositive sanction. I can, draw an adverse inference or exclude evidence. So I have a great deal of authority, not to mention there's a general sanction rule where I can sanction parties, for fees and costs. And so again, it's important that the arbitrators know this, or if you have an arbitrator that doesn't, to do your research on the rules and to make sure that you know it, but definitely like participate very actively in that first preliminary hearing and scheduling conference so that these kinds of issues that Neville is raising can be addressed on the front end of it. And I think that's probably the best way to make it a better process, more cost efficient, more effective, and to eliminate or at least reduce the chances of some of the things that Neville talked about that he was involved in. We're coming up onto 1:59. I don't know about the rest of the panelists. I hope so, but like I'm happy to stick around if anyone has any questions that we need to deal with.
I'm happy to stick around too.
Yeah. And
well, I'll stick around too. I didn't say. I am in San Juan, Puerto Rico right now, where I've been doing depots. So here I am. And I want to say in closing on this, if I think most of the people watching know this, but the Supreme Court of the United States is in love with arbitration. So get used to it. It's here.
All right, Paul,
yeah.
Do you want to go? We have questions in the chat. Did you want to go through those? And it says Q&A down there. You see the window?
Yeah, I see. Yeah. We have one question that talked about that can an arbitrator vacate their own awards? An arbitrator can, as long as the award is interim, the arbitrator can change the arbitrator's mind. Once it becomes final, there's very limited, like changing, typographical errors or errors in calculation. But after a final award, the arbitrator becomes functus officio, meaning that the arbitrator has no more power to vacate an award. So the way that an award would get changed is as initially an interim award where somebody is seeking to reconsider it and the arbitrator is changing the position or dealing with an issue that they failed to deal with.
And I'll just add to that, in most large cases, they're going to issue an interim award before they're going to issue a final award. So as soon as you see that interim award, that's going to be your opportunity to say something, and you should say something very quickly.
Also, someone raised a question about thoughts about studios charging the attorney's fees incurred in defending an arbitration to the series at issue and the cost of distribution. Neville, have you ever seen that happen, or any thoughts about that?
Say that again. What's the question?
It's any thoughts about studios charging the attorney's fees incurred in defending an arbitration to the series at issue as the cost of distribution?
I haven't seen that, but it sounds like something they do.
Yeah, I would just say that, if the studio happens to win and the arbitrator awards them attorney's fees, and the losing party doesn't pay those fees, I don't see what would prevent them from taking that from future distribution.
I will say, though, that most of the agreements that I've seen do not have attorney's fees clause. And I think they do that because they say, we're big, we're rich, and we'll drive you into submission with attorney's costs.
That's right. I think everything here. There's another question. Most talent agreements expressly preempt injunctive relief. How does this apply in the context of entertainment cases?
Well, I can tell you that I'm aware of a recent case where there was somebody who was under a confidentiality agreement who blabbed, and there was an immediate going to an arbitrator who issued an injunction, which was then upheld by the trial court at that time. So it does occur and can occur.
And I just also want to point out too that, as far as any kind of a one-sided arbitration clause, I think Neville made reference to the Armendariz case, which is a landmark decision of the Supreme Court, I think dates back to 2000 or 2001 in the employment context, but it really tells us what's fair in arbitration, and there has to be mutuality, and it can't be one-sided, and there has to be at least in the employment context that the court was ruling on, there's got to be some ability to do some discovery if it's necessary. But again, on Neville's point, it's critically important that it be efficient, fast, and any disputes be dealt with, not like court, but very efficiently and informally, so that everything can move along cost effectively.
My last arbitration, which was, I don't know, 4 or 5 months ago, was entirely on Zoom.
Yeah, almost all of the ones that I've presided over since the initial lockdown have been on Zoom, and people are still choosing Zoom in cases where, they're in different parts of the country. I actually, I've only done one hearing in person since the lockdown. So we really adapted very well to Zoom, and it works very well. And I think most lawyers have had contact with it now. So that can be another way to keep costs down and, not require travel, every which way.
And I'll just add to that. I'm starting to see a lot of hybrid hearings as well. So maybe we just have the arbitrators and arbitrators and the attorneys, and maybe key witnesses, but minor witnesses and things like that can just Skype in or use Zoom or something like that. I'm seeing a lot of that.
Yeah, and you'll save a lot of money if you don't have a court reporter.
And that's another big expense, obviously, is the court reporter.
Well, I guess that wraps it up. And if anybody has any additional questions, you have our contact information. I mean, feel free to shoot us a question at any time. We'll let Neville get back to the sun and fun and send on. Thank you.
I'm
so
on,
much, Neville,
I'm
for
on
joining.
LinkedIn. If you guys want to send me a connection request, you can follow my interesting posts about arbitration and whatnot. I try to post something every week that I find interesting in the ADR world.
All right, well, thanks for this and God bless. See you all later.
Thanks, Neville.
Aaron, thank you for
Bye,
all of
Paul.
your contributions, and thanks everybody for
Thanks
joining
for
us
joining.
today.
Yeah.
Have a great rest of the week and a great 4th of July, and we'll see you again soon with advanced techniques, maybe next year. Take care.
All right. Bye-bye.
Thanks.